I wanted to ask you, what kind of claims, or what's the number one type of employment law claim you see from workers' compensation claimants?
Okay, I don't know if I have a number one, but typically you have, when an individual has an ongoing claim in the workers' comp system, you see one of three types of claims. You're going to see a claim that the workers' comp retaliation under that statute, that somehow their injury is causing something against them, a claim for disability accommodation requirements, or a claim for how their payroll is being done, where it was done incorrectly.
Okay.
Have you seen similar claims?
I see employment law claims tailed onto or pinned onto workers' compensation claims, and somehow, some way, some lawyers think that this adds value to the claim, right? Especially when we come into the settlement phase of it in terms of a release, because that's what my clients generally, I recommend that too, a release when it comes to settlement. And a release of all claims is part of what we do. So a employment law claim such as retaliation can drive up this perceived value of the claim. So retaliation, discrimination against a work injury type. So yes, I have seen that, unfortunately.
All those statutes I referenced include an attorney's fees provision, which is not commonly present, or at least not as lucrative in the workers' comp system. I've also found that they try to use that in order to obtain a larger fee award from the claimant. When you mentioned workers' comp retaliation, but the disability component is because you have an individual with a medical condition already, they're claiming injury, which is borderline to disability anyway. So injury, restriction, there is some overlap and some obligations associated.